fairly well known, which are called B corporations, B standing for benefit or public benefit. And that's a designation that was created and is used in the market by an organization back east called B Labs, which some of you may have seen. And an Oregon benefit company, either an LLC or a corporation, could become a B corporation, but would have to be certified by B Lab.
Have any of you represented companies that have gone through the certified B corporation process with B Labs? Raise your hands. So some of you are familiar with that process.
And then last on this page, I'm going to flip pages here. Sorry. At the bottom of the page, there's a citation to an article that goes through and compares the legislation in a number of states. So if you want to see what's out there and how the legislation differs state by state, that's a pretty good resource. In the material, you'll see that we tried to capture what we think are the central aims of the benefit company legislation. One, these companies that decide to opt into this designation will have at least a general public purpose. And that means, in essence, a public purpose that will have an impact on society and the environment taken as a whole. The Act modifies what fiduciary duties otherwise would apply in the case of a corporation or an LLC, and it requires the fiduciaries to take into account.
I think in that bullet we may have inadvertently omitted the words material positive before impact.
That was editorial oversight. It requires the fiduciaries to focus on the impact of decisions on multiple stakeholders, and we'll talk about that a little bit. And then finally, it introduces an element of accountability, requiring an entity to report out to the world and its stakeholders how the company has performed against an independent third-party standard. So let's just take a second and talk about what is a benefit company, how you get there. We mentioned that an entity is a Chapter 60 corporation or a Chapter 63 LLC that's either incorporated or organized or formed or created under Section 3 of this new Act. It also includes PCs, as I mentioned earlier. So how do you elect in? You elect in by putting a statement in your articles of incorporation, articles of organization, that the entity is subject to the Act. If the entity is already formed, then you amend your documents to say that the entity elects to become a benefit company under the Act. And we'll talk about the status vote, the minimum status vote that are required to opt in. There are also ways of getting there through various forms of conversion, merger, or exchange of equity interests. So it's possible to become one by combining with another entity that we'll talk about a little bit. And then I think here, to your point, Bill, we talk about the entity is supposed to have a material positive impact on society and the environment taken as a whole from the business and operations of the company. So I'm going to pause there, and I think, Bill, you'll comment on this next part.
So how many of you have sat in a corporate boardroom and advised boards of directors on their duties to shareholders in a decision they want to make? And how many of you have found yourself saying, well, as long as it means that you make more money that way from doing it the other way, and that you have a good reason for doing that, you can do pretty much what you want, right? And how many of you have wished at the moment you said that you could have really said something else, which would have been something more like, look, let's do the right thing and let's figure out how everybody does right by it. How many of you have wished you could have done that? And how many of you think that the boards of directors that you were advising also wished you could have done that? All right. Well, this is the reality that all of us in this room, with very few exceptions, have spent all of our professional careers operating within. And it is a reality that stems directly from a series of Delaware cases, which ruled with explicit clarity that boards of directors of corporations have the fiduciary duty to maximize shareholder wealth. And in fact, they defined fiduciary duty as the maximization of the wealth of the shareholders. It didn't always used to be that way. By that I mean not that fiduciary duty didn't include the concept of maximization of shareholder wealth. I think anyone who has ever practiced corporate law would say, well, no, that's a part of your fiduciary duty. But in business schools in the late 60s, you would have been taught that your job was much more holistic than that. You would have been taught that your job included thinking about all of your impacts. And by the way, your job was to make money for your shareholders. That's what companies were for. But you ought to do it in a way that was good for your employees, that thought about their benefit, that was good for the communities you lived in. Those were all part of how you did it. And business schools taught this. After Revlon and after Unical, business schools could no longer teach this. And if you, how many of you may have an MBA today? Any of you? There's always a few, right? When you were in business school recently, what did they tell you your job was as the manager of a business on behalf of some other investor? Maximize profits. That's it. That's what you get taught today, and it's different. So the first thing I want to observe is that the world that we've all practiced in is actually new from the point of view of the duty of business owners. It used to be much more holistic. Now, almost immediately after Revlon and Unical came down, there was a revolt against this concept. It felt like it was too much. And a number of states passed what's called a constituency statute. We did here in Oregon, and some people here in this room were involved in that. Dick, you were involved in that, weren't you? And Jim and Jeff, you probably were when we were wrestling with that. The constituency statute, which appears in ORS Chapter 60, says, and it's in the statute today, that when you're thinking about selling the company, you're allowed to think about impacts on stakeholders and other stakeholders in the environment. We're all familiar with that. So that's fine when you go to sell the company. And it was always a little ambiguous as to what you could get away with as a manager of a company in other settings, because you still had the benefit of the prudent judgment rule and the benefit of the deference that you were accorded by courts about your judgment. And you could always figure out that in some long-term way, this thing that you were doing was better for shareholders, but it was sort of indirect. Some of us in this room attempted at a couple of different times to bring more clarity to the law that you could bring this balance into standard corporate governance. Jim Kennedy, Jeff Wolfstone, Dick Roy, I played a small part. Others of us attempted to extend the constituency statute by eliminating the limit that would only apply in the case of the that it would only apply in the case of mergers or sale of the company.
Takeover.
Only apply in the case of a takeover setting. And we thought it was just sort of smooth sailing. And then we ran into an interesting phenomenon, which is when one of the state's biggest employers shows up at the hearing on which you are supposed to be voting at this and says, "We don't like this," it turns out the legislature pays attention. And it turns out that they don't actually have to say why they don't like it. It's sufficient that they don't like it. And so that effort didn't get across the finish line. So when we brought this bill to the table, a number of us were looking at it saying, well, you know, you can actually write standards that are consistent with benefit company standards into the governance of ordinary companies. Oregon law is very flexible on this. Oregon LLC law is even more flexible than the corporate law. You can put any provisions you want for the governance of a company into the formation of an Oregon corporation or an Oregon LLC. And in fact, Jim, you and Jeff, I think you and Dick and some others reinforce that concept by the addition of a phrase up front in ORS Chapter 60 a couple of sessions ago that basically said, look, it's fine if you want to write in something for public benefit or other kinds of things into your laws. And you can go look that up. That provision I think of as the Kennedy provision in Oregon law. One of the very clever things that Jim and Jeff did was they added legislative history language that basically said, look, this doesn't change anything, it just makes it explicit, which I thought was really cool. Right? Because what it meant was that people who'd already done it didn't have to feel like they had to redo it. And if you didn't do it, it didn't mean that you couldn't later, right? The absence of it, it wasn't a negative pregnant. That was what the legislative history did. So all of that was fine. And I thought that you probably didn't need legislation like this. But then this case came out that this quote is from on the next page of your handout on page 5. This is the eBay Domestic Holdings versus Craig Newmark and James Buckmaster case, colloquially known as eBay v. Craigslist. And this came out in Delaware relatively recently, within the last several years. And what it did essentially was demonstrate the difficulty that the Delaware Court of Chancery has had over the years wrestling with this issue. And really the most telling thing here is the concept that the Inc. after the company name has to mean at least that it's for profit. Because what this did is it called into question in Delaware and therefore all across the country whether forming a corporation in and of itself meant that you could not do the kind of fiduciary duty changing that we'd been doing by simply amending articles and preparing articles that included benefit corporation type provisions. And it's been a problem in the attempt to rebalance the concept of fiduciary duty in American company life. This case is a very interesting one. It is Craigslist. So Craigslist is a for-profit company. It was organized by Craig Newmark and James Buckmaster and one other guy. The other guy sold to eBay. eBay logically thought that they'd bought a corporate share and that the idea was to go make money. They came into shareholder meetings and said, okay, let's go make money. Here's all our ideas for doing that. And Craig basically said, nah, we're Craigslist. We kind of just want to serve the community, and we'll make enough money to keep going and so on, but we kind of just want to serve the community. And in the course of protecting their ability to do that, Craig and James Buckmaster entered into a side agreement, a shareholder agreement, a rights agreement, some other kinds of things to protect the concept that Craigslist could go on being Craigslist. A very interesting thing that happened in eBay is that the Delaware Chancery Court reminded us that majority shareholders take on, if they are the majority shareholder, take on fiduciary duties, whatever that means, to the minority shareholders. And essentially the Delaware court said, even if you think that as a director you have these duties, but you have to be paying attention to what your shareholders say, because you guys entered into a shareholder agreement that said you're governing this thing together, you've just become a majority shareholder, and now you owe the same fiduciary duties to eBay, and you have to go make a profit. That's how you have to decide these things. The reason that was a big deal is a number of us had been working on a concept called mission keeper equity. The idea of mission keeper equity is you don't have to worry about fiduciary duties that directors have because shareholders can do anything they want. They don't have fiduciary duties to other shareholders. And so you guys may remember about 6 or 7 years ago, Cadbury's attempted to take over Hershey's Corporation in a hostile takeover. You remember reading about this? It was like the Easter Bunny tries to buy the Hershey bar. And they offered a 37% premium to market. And the Hershey's Corporation Board of Directors, in the exercise of its fiduciary duties, looked at it and said, we have no idea how we're going to make this thing worth 37% more than it is now, so we really have to recommend this to our shareholders, and they did. It turns out that the controlling vote in the shareholder set of Hershey's Corporation is the Hershey's Trust. The Hershey's Trust was set up by Mr. Hershey originally, and its duty is to, as a trust, as a foundation, is to take care of Hershey, Pennsylvania. And the trustees of the Hershey Trust, logically enough, said, yeah, okay, we'd have a 30% higher trust and we'd need vastly more than that to take care of Hershey, Pennsylvania because everybody would be out of a job. And so they voted it down. P.S. They then promptly replaced the board of directors with people who had a concept of how to make the company more successful. That vote under this eBay case would be called into question. Someone logically could say to the Hershey's Corporation Trust, you guys have the controlling vote, you owe us a profit. That's a problem. When I read this eBay case, I realized that actually we had to take this whole benefit company thing pretty seriously. And so we started working on the benefit company legislation. So we'll go on and talk more about that. But that background that essentially says if you want to get back to the place where businesses were allowed and business managers were allowed to bring their whole humanity to the management of their businesses, to think of their business as well as themselves as a citizen of the community with a citizen's duties, then you needed a framework to do it that allowed that way of thinking to be legally protected. And that's really what benefit companies are all about. You can go beyond that. You can stretch it beyond that. You can add special benefits. You can recognize, you must recognize that you have a general public purpose along with whatever other purposes you're being in business for. But for me, it's the rebalancing of these fiduciary duties so that your clients' businesses can think of themselves as citizens in the same way that your clients do, that this bill will make the most difference for Oregon companies. Enough of a chatty background.
So I hope that's helpful in the way of background. I'm going to take a slightly different view on part of this, and that is that going back to the legislative history that was put into the Chapter 60 a while back, we did take the view, and I think it was an honest view, that Chapter 60 business corporations are not quite so tightly bound and are probably not going to be held to the harsh standard in this eBay v. Craigslist case. So don't give up on business corporations. And if you want to look at, some guidance on that, I think it's the ALI Principles of Corporate Governance, which talk about the ability of companies to do things that are not strictly aimed at profit maximization. There is some room there. So don't give up on Chapter 60 business corporations, but look at this as a place where the right company at the right time might be a good candidate to be a benefit company.
I think that makes sense, and Oregon's law is more liberal in that sense than Delaware's law. It does contain a constituency statute that recognizes these other things can come into play at the ultimate profit maximization moment. It does contain the provision that you guys added, and a court would have room to say, well, no, you can be a little more expansive about the duties here. My worry is always that we as lawyers, our job is not risk balancing. Our job is risk elimination. That's why people hate us, right? Because we always say, well, no, you can't do that because, right? And the because is always because there's a risk. Well, if someone wants to know, can I do this? Am I absolutely safe doing this? Then the eBay case I worry about. And I think that a benefit company is not going to have to worry about the eBay case. So that's the context in which
Okay.
I think about that in Oregon.
All right, so let's move on. We're going to go through the more mechanical aspects of this so you get a flavor for it. It's not very complicated, but there are a few important aspects. So we have a concept of a minimum status vote, and that's the vote that needs to be taken by the equity holders to either opt in or opt out of benefit company status. We have the concept of not only a general public purpose or general public benefit, which we had in the quotation that we looked at a little bit earlier, but we also have the concept of specific public benefits. This is an optional provision, something that a benefit company can decide to expressly put into its articles, but is not required to do so. We have the concept of governors, and here it's a term of art used to cover the fiduciaries, directors, managers, or members. We have a modified fiduciary duty, which we'll take a look at. We have a third-party standard concept, which we'll take a bit of a further look at. The company needs to annually provide a benefit report. Then there's some enforcement mechanisms, and then there's some limitations of liability that we'll talk about. But before we go to that, one of the things that's maybe a little bit of interest is what, aside from the general public benefit, what are these, what are some examples of specific public benefits? And this list of, which is non-exhaustive, and it's not a required list, you can write your own ticket, but this is a list that the drafters of the model legislation that we looked at in the beginning had posed. So it's something, if you're going to be working with a company and you're deciding whether you want to look at including specific public benefits, first think very carefully about it, because what you do put in there, you're going to be held to it. But these are some examples of the kinds of things that might appear. We have some examples of materials that we'll take a little bit of a look at later. I think Bill will walk us through it, but some companies that are out there running from big to small, and we'll come back to that. So let's then turn to the...
By the way, Jeff, one of the interesting things about this list of specific public benefit and the concept of specific public benefit is I don't think that the specific public benefit needs to be independent of the business's core line of business. This will be an interesting topic of conversation as these things come forward. But for example, if you are in business to feed people, that is a specific public benefit, and maybe you run a restaurant, right? How does that work? How does that go from, is it greenwashing or is it a specific purpose? Well, what if you ran a hardware store and you added as a specific public benefit that you wanted to feed people, after hours, or you wanted to feed the poor after hours? Are those two things, is one meant within the law and the other one not? I don't think so. I think you can run your business with the idea that you are bringing a benefit to the public, that is the purpose of what you are doing. And it will tend to affect how you think about the way in which you bring that, core offering of your business forward. I think that's a positive thing, but it's going to be a topic of conversation.
So opting in and opting out, how do you do it? In addition to any other vote that you have to obtain, in the case of an LLC or a business corporation, or a PC for that matter, you need a majority of interests entitled to vote to approve opting in or to approve opting out. And then first I'll note that we had a fair amount of divergence in the committee as to whether we would go with a majority vote or a higher vote. And I note that most of the other states where this kind of legislation exists is at a 2/3 vote. I personally was advocating for a 2/3 vote. I didn't carry the day on that. And Bill, maybe you were more interested in a majority vote, so you might want to talk about how that came to be prevalent.
I was actually a fairly mild preference in this regard, because there's a lot of good arguments both ways about what this should be and whether there should be things like dissenters' rights, which ultimately our statute did not provide for on a change from a standard to a benefit company. But the logic that I had for why I preferred the lower was, you can amend your articles now. If the articles provide for a higher vote, then that's fine. But just as we were saying, under a standard Oregon C corporation or Chapter 60 corporation, you can amend your articles to include the same governance kind of provisions by whatever majorities are permitted for the amendment of the articles. Why impose a higher standard for something under which you actually are taking additional duties? That was my logic. Nonetheless, it's non-trivial to understand that a minority shareholder could get dragged into something they didn't mean to be in the first place, and that's basically the argument for a 2/3 minimum status vote in the legislation nationally. A very interesting thing happened in the course of drafting, which is we went out to Oregon's largest C corporations, and we said, what do you think about this? And we went out to the OBA, what do you think about this? And in other states, going out to the business community, the answer from the business community had been, we need dissenters' rights, we need 100%, or maybe 90%, or okay, well, 2/3 if you absolutely have to, but make it really, really hard, and a whole bunch of other stuff like that. In Oregon, something very different happened, and it's a credit to our business community, from the very largest to the very smallest companies. Our business community came back and said, you know what? We kind of like a majority vote. We wouldn't mind at all that companies have an easier ability to get into this. That was unexpected for me. I think it was unexpected for you too, Jeff, and maybe for some of the others who were working on it. Diane, I think it surprised you too. Diane Henkels, who did so much work on the bill. Yeah.
So if you follow the whole Craigslist case line of reasoning,
Yes.
is there an argument that you have sort of a majority shareholder fiduciary duty not to circumvent the Craigslist line of reasoning by taking this vote?
There is, and the answer to that is no man's life, liberty, or property is safe while the legislature sits. Okay? We now have a bill that says, sorry, you're trumped. Okay? The legislature's entitled to make rules about that. But there is an argument for it. It's a non-trivial argument, and it's why some other states have put in things like dissenters' rights provisions. So it's non-trivial. And in fact, the logic of that was in part why the second set of provisions in here, the National Securities Exchange provisions, were put in. There is at least one substantial Oregon company that said, look, we don't mind this, this is fine, but let's recognize that we're out there trading on a national exchange, and we are organized under the Oregon statutes. And if somebody, through shareholder action or whatever else, I'm not quite sure, since boards of directors have to approve an amendment to the Articles of Incorporation, how you could get there just by a shareholder vote, but they had a theory of how it might work. What if they pushed us into this, and suddenly our stock price goes kaflooey? That's actually what they were worried about. Or, alternately, what happens if we have a sort of a special control class of stock that loses its controls threshold but still is meaningful? Some of you who are aware of the structures of some of Oregon's larger corporations might have an idea of who might have thought about that. And it was really actually thoughtful. they came back and they said, well, what if we thought about it this way? So for the listed companies where there's this large settled expectation, the 2/3 vote was preserved, and something else was preserved too, which is class voting. Whether it's class voting or not in other Oregon companies is a function of the articles of incorporation you originally prepared, going back to the logic that says, hey, you could put these provisions into the articles now by whatever the amendment is. There's no reason to set a higher standard. Does that help?
And there's a second exception also, which is that the entity can adopt a higher threshold in or out.
Correct.
And so that was another change that, so you could provide your own 2/3 requirement if you wanted to. I think we've probably done enough with this, so let's move on. We talked about who governors are. So a benefit company must have a quote-unquote board of governors. In the case of a corporation, it's board of directors. In the case of a manager-managed LLC, it's the managers as a group. In a member-managed LLC, it's the members as a group. And they can optionally have a benefit governor, which is in some of the statutes around the country. And it's not required, so if you do have this person, though, you can give other duties and powers. And if they do have one, the minimum requirement is that that person is to provide information or statements to other governors concerning their decision-making obligations, which we're going to talk about. Do you want to comment on this one at all?
Fundamentally, the idea is you may actually want to have one governor whose job it always is to remember that the company is a benefit company and to bring that back to people's attention.
And I think there was a counter position maybe that all the directors all the time should be
right.
benefit governors.
And ultimately, you'll see over and over and over again the Oregon Lawyers Drafting Committee and ultimately the legislature defaulted to the theory that Oregon companies are smart enough to figure out which way works best for them. We don't have to tell them ahead of time which way it is. Let's provide a flexible framework.
Okay. We talked about the fact that fiduciary duty, which goes back to the Delaware case that Bill referred to and other cases. The question was, what should the governors be thinking about? What should the board of directors, what should the managers, what should the members be considering? And their obligation basically is to act in the best interests of the company, considering, in addition to general best interest, how decisions will affect, and then we have a list of enumerated constituents. So it, in a sense, turns what Bill was describing earlier upside down. It says, no, these are the people that you need to be thinking about in addition to what's generally in the best interest of the company. Do you want to comment on that?
Yeah, it's actually it's actually defined in such a way that thinking about all of these things is what the best interest of the company means. It's not first there's the interest of the company and then think about these other things. It's an understanding that the company exists holistically within this setting. In that sense, it's going back to what I think of as an older way that companies were governed. In that sense, sometimes I say, you know, this is deeply conservative legislation masquerading as a progressive innovation, right? It's really giving us back the way companies used to be operated, because this is normal, right? If any of you advise family-owned businesses or stockholder-managed businesses, it would be bizarre for them not to think about all these things all the time, because they're just people, right? They're just thinking about this. In our smaller communities around the state, this is normal for businesses to be that kind of business. So a lot of those businesses don't get why we're even talking about this. And the real reason is that in the larger businesses that some of us advise, there's a separation between the interests of one or more shareholders and the identity of the managers making decisions. And it is for those folks that benefit companies really become necessary, and this kind of thinking is then re-allowed. So this basically says, managers, you're entitled to bring your whole humanity to the decision-making.
And I think the further point here, just to note, is that there's no prioritization given unless the company decides to adopt some priority among these interests in their articles. The next concept is the requirement of a third-party standard. And this is really, we're getting to the point about accountability. And I think there's a lot of interest around this point. The mention was made earlier of concerns about greenwashing, and I think that remains a concern with the statute, without the statute, namely making claims of doing good, but not really being held to account what that good consists of, what efforts were taken, what successes were met, what failures occurred in the attempt to do that. And so a company that becomes a benefit company, at least on the general public benefit, and it may also on specific public benefit, be required to measure itself against a third-party standard. And that means that the company has identified a recognized standard to define, report, or assess an entity's social or environmental performance. And the company has to establish criteria that apply to all the interests above. Again, you don't have to prioritize one over another unless your articles require you to do so. The standard is developed by an organization that's not under the control of the company or its affiliates. And that there's publicly available information about the measurement criteria and the weighting used, the process by which the standard is developed, and the organization takes steps to sufficiently disclose any relationships that might compromise the standard-setting organization's independence. And then, go ahead, why don't you dive in there?
Sure. Think of these in three categories: independence, comprehensiveness, transparency. Those are the three requirements for the third-party standards you use. Other states have actually had a rigorously defined, almost regulatory complexity list of definitions of what these concepts mean that fundamentally would have, in our view, stifled innovation. And what we thought of as innovation is there is a set of standards that, for example, B Labs uses for certified B Corps. They basically use the GEARS standards. I don't know how many of you are familiar with the GEARS standards. Did we include a handout about GEARS in here? So, and they're comprehensive against the criteria in 10. They're really quite exhaustive. And there's some question about how they link with where the assessment of these sorts of provisions will want to go at some point. Well, in Oregon, what we said was, for any different industry, there might be a better way of doing this for that industry than for others. There may be a way that it ought to do it, and the development of that ought to be something that the companies in the industry can help do. In fact, many sort of purpose-driven businesses have helped push the standards forwards on things like organic farming or FSC, forestry, other kinds of things. And to say that it had to be completely independent of the industry was unrealistic. So we were looking for more flexibility. The other thing that happened in this is that in Oregon, the election was made in the drafting process from the very earliest time that the third-party standard could be something the company would apply to itself as long as, and you're going to talk about the report on the next page, as long as it reported against it. What we weren't insisting on was that we were creating a necessity for Oregon businesses to go hire an auditor against these standards. So it wasn't a question that you had to submit to a third-party process. You have to submit to a third-party standard that is transparent, independent, the organization is transparent and independent, and the standard is comprehensive against the criteria.
And so the entity has to each year prepare and deliver within 120 days after the end of the fiscal year, or if it otherwise has an annual report that it sends out, to each holder of equity interests, a benefit report. And the benefit report is required to include a narrative of the extent to which the company provided general public benefit and, if applicable, specific public benefit, and the actions taken and methods used to provide the benefits, and also to state or disclose circumstances that hindered the provision of benefits. The report is to assess the extent to which the company met or exceeded the third-party standard in a manner consistent with previous reports, or if not consistent, to explain what those inconsistencies consist of. To describe the process and rationale for selection or change of a third-party standard. And the reports must be posted on a publicly available website, or copies must be provided without charge to any person on request.
And we have a couple examples of reports that companies have prepared against similar standards in other states in your materials. We deliberately chose some from sort of opposite ends of the spectrum. The requirement is that you hold yourself accountable essentially to the public, certainly to your shareholders, but essentially to the public against these things. And whether it gets really beautiful, like this Grayston Bakery one, which looks like a full-fledged public annual report, and this is a substantial company, they do some good work, or whether it's really just a, here's what we're trying to do from this little startup called Mob Rules, it's okay. The point is the process. The point is holding yourself accountable annually against these things and making sure that you keep yourself, that you remind yourself that this is your job too.
Then our last topic, enforcement mechanism and limitations. So this was a pretty hot topic in the drafting. Who can hold the company and its fiduciaries responsible? And the conclusion that we reached was that benefit company itself, nor its governors, could be held liable for failure to pursue, create, or provide a general or specific public benefit identified in its articles, or for violation of a standard of conduct under the Act itself, except, and these are the areas where there could be responsibility, the company, a governor, a shareholder, or another person identified in the articles or bylaws who is given a right to commence such a proceeding may, and then bring an action basically to enforce, to compel the company to provide the benefits, or require the governors to act in a way that will result in the benefits being sought. So it has basically an injunctive aspect to it, but not a damages aspect to it. Do you want to comment on that?
Yeah, I think that's right. The idea here was you've got to have something that can enforce it, but this shouldn't turn into a great cash hunt. This should simply be, you know, this actually matters, and you do owe these duties, and you ought to be paying attention, and there's a formal mechanism if you're being cavalier about it.
So I think that's a quick overview of the Act, and we're right up against 1 o'clock. We've got about 15 minutes, and we'd be happy to take any questions. Mike.
So page 4 of your materials kind of gave me a start when I read through it. Down at the bottom of the page, it defines general public benefit, which I think means that's something that every one of these companies has to have, right? I'm looking at the phrase taken as a whole, and I'm not sure what that modifies. I hope it doesn't mean that we have to have a material impact on the society as a whole.
It's actually,
Repeat the question for the people on the phone.
yes, thank you. The question was, what does this taken as a whole mean in the definition of general public benefit? Because it's sort of ambiguous where it's placed. You are making an observation, by the way, that Legislative Council shared. And Legislative Council helpfully edited this clause in such a way that it didn't mean quite the same thing. It wasn't that the meaning that Legislative Council gave to it was either better or worse in some fundamental sense, but it was different. This language, including its sort of embedded ambiguity, if you will, is the one thing that is consistent across all of the benefit company laws around the country. The basic structure is consistent, how much detail is there is different and so on, but this definition is one of the things that's consistent. The other is the list of stakeholders that everybody needs to be thinking about and accountable to. So in the drafting process, when Legislative Council came back and essentially Mike had exactly your observation, this is a little obscure, right? The decision was made to leave it obscure. But let me tell you what the sort of the greater legislative history around this is, right? The taken as a whole is about the impact. That is overall, what's your impact? Not overall environment, but overall, what's your impact? A material positive impact taken as a whole, considering everything you're doing and the balancing and so on that you have to do back and forth, because you're always going to have trade-offs, right? And then from the business and operations of the company. Right? So it's from everything you're doing. And I've understood this standard in that context as you're not allowed to just do something nice on the side. You know, you can't go to church on Sunday and sin all week. Right? This is, you got to run your company this way. And you got to think about this as you're running your company. Again, it doesn't mean that you have to do something different than your core business, but you better be running your core business with this in mind. I don't know if that's helpful.
Other questions? Neil?
Are there any IRS rulings that say that expenses for doing this public benefit are reasonable and necessary business expense?
No.
I guess we would say,
Are there
I
any-
don't think, no wait, I don't think.
Repeating the question.
Okay, I'm going to repeat the question from Neil. The question was, are there any IRS, are there any tax cases or rulings that would indicate that taking these actions look, in the nature of either trying to achieve a general public benefit or any specific public benefit, that those actions would constitute ordinary and necessary business expenses that would be deductible by the corporation. And I think the answer is we really haven't looked at that, and that's a really interesting question. And it may be a little early in the genesis of these entities to really know how that'll be looked at. I would be inclined to think, just as an editorial matter, that there's probably quite a wide berth there to have these count as ordinary necessary business expenses.
See, this is the wonderful thing about moving from actually practicing law to having once practiced law is I'm pretty sure the answer is no. But Jeff's right that who knows if there's something obscure somewhere that we haven't actually looked up.
Okay.
The reason I'm pretty sure that the answer is no is that benefit companies only just got invented. The first statute on this was passed like 2 years ago or something.
Well, a little bit below, like 2008, 2009.
Okay,
Yeah.
Well, in different forms.
Yeah.
But the point of that is that it's unlikely that something would have found its way all the way through those provisions. But yeah, it's going to be an interesting question. Dick?
The crux of that for a lot of people is the business model or core product line. On the general public benefit, in your view, can Coca-Cola pass that regardless of its conduct based on its product?
Okay. So you're going to answer this question, Bill, and I'm going to restate it. So Dick Dick's question,
Can't I restate it and you answer it?
no, I'm going to restate the question. So the question is, could Coca-Cola, the company, make it as a benefit company under this definition of a general public benefit?
Yeah. So you're really asking for a moral judgment from Bill Campbell on the selling of sugar water. And I think everybody has their own theory about the moral benefits of selling sugar water. And clearly, you're also observing that Coke as a company is well known for its charitable works and for treating its employees well and things like that around the world, and is that enough? For me personally, the ethical case around Coke is a much closer question than the ethical case around Philip Morris, another company that treats its employees extremely well and then sells products that kill people, right? Those are, I think, exactly the sort of questions that are not up to me independently to decide, but are up to the board of directors of a company like this to actually wrestle with. To say, you know, is this thing we're in business to do, is this actually good? Can we, it's for them to answer. So could they organize themselves into
Well, we have a
this? Yes.
follow-up question from Dick.
If it's totally subjective to the board, the answer will always be there's a general public benefit because corporations organize their energy around doing good things. But if you're saying Coca-Cola could say, even though, well, we're killing children or embedding obesity, if the board comes with conclusion, they've already probably concluded that, so they can sleep at night.
Well,
So
yes and no.
Let me state,
Okay. Yeah, sorry.
restate in short Dick's comment, which is that a board is likely to be generous in its own self-evaluation. And in the case of Coca-Cola, perhaps the board would conclude that they actually are meeting this standard, and therefore they can sleep at night. But I'm gonna append that with a different question, which is, what's the likelihood that a publicly traded company would become a benefit company? And what issues does that put out in front of the investing public in today's world? Do you want to take a swing at that?
Sure.
Like if eBay, if this case were to come up again, it probably wouldn't happen in the case of, if it was a benefit company, but is it really likely that public companies are going to enter into this bargain?
I think the answer is yes. I think the answer is almost certainly yes. I don't think we've seen the first publicly traded company become a benefit corporation, but the reason is actually the capital markets. The capital markets now have, in a number of different ways, started to express an overlay of good governance, good social policy, and good environmental policy on investment decisions. I don't mean across the board they have. They certainly haven't. There's people who have all kinds of different investment theories. But one of them that is emerging is so-called ESG indexing, right? So environmental, social, governance indexing. And what the capital markets are doing around this is they're basically saying, look, I got a class of investors who actually thinks either that they want this so they can sleep well at night, or that they believe that there's a correlation between these policies and better financial results. And by the way, there's some data behind that as well, which is kind of interesting. So I think you're going to see companies taking advantage of that. And chances are they will begin to take advantage of it before they're public, because there are sources of money that require qualifications either as a certified B-Corp or a B-Labs or other kinds of things that will create growth paths for companies through the stages where ultimately they qualify for being publicly traded. What will be interesting, Dick, is if there is a company that today is not a benefit company and that elects to be a benefit company, what will be the impact on the stock price the next morning, right? And then what will be the impact on the stock price over the next 2 or 3 months and 2 or 3 years by comparison with the peers it usually assessed itself against. We don't know the answer to that. I can tell you that the range of possible answers to that scares corporate counsel a lot when they think about this, and it's one of the reasons why we're very carefully with Oregon publicly traded C corporations in this bill. And I think we can all understand why that is. I actually am optimistic about the ultimate answer to that question, but we don't know yet.
Is there any ability to pick 2 out of the 3? In other words, if a company wanted to focus on profits and people and leave out the planet part, are they able to do that?
You mean like run your business on Mars? Is that- no, you can't. Not and be a benefit company. By the way, there's nothing that stops you from including those 2 provisions to be like a social and profit company and forget the environment. We'll poison the Willamette as long as our people have health care, right? I got it. But it's no, you can do that if you want. You just can't do it as a benefit company. So you can write those provisions into your organizational actions, your LLC organization, your operating agreements, your articles of incorporation. You can do that fine now if that's what you want to do. It just isn't a benefit company.
We have another question.
Can an existing Oregon nonprofit company become a benefit company without going through dissolution under Chapter 65?
Good question. So the question is, can an existing Oregon nonprofit corporation become a benefit company without basically disincorporating and starting over? We haven't really taken a look at that, but I'd have to think about whether they could convert under the provision for conversion and become a benefit company. There are other issues that you deal with. For example, you may have duties to the public as a nonprofit, and moving out of the nonprofit realm to essentially the business realm, you may have to answer to the AG.
I think the answer is it doesn't translate directly that way.
Right, okay.
So a not-for-profit company in Oregon has an ultimate residual beneficiary, which also has to be a not-for-profit. An ORS Chapter 60 company or an LLC has somebody who owns its equity interests in some ways, right? And so that translation can be done, but first you have to translate into being a company that can be organized under ORS Chapter 60 or ORS Chapter 63, that is, you're a corporation or an LLC, and then you can become a benefit company, because the benefit company statute is specific to those, and I guess you're saying Chapter 58 too, which I'd overlooked.
Right. Okay. Good question. Next, Josh.
Can you say more about where these third-party standards would come from?
Right.
Or what would constitute
Right.
a recognized one
Okay.
versus a non-recognized?
Okay. So question was, for those on the phone, where did these third-party standards originate? What are they? Can we give some more examples of them? We did give the one example, which we're not here to shill for B-Labs, by the way, although they've been very active in this space and promoting this concept across the country. And I think we want to make clear that there are other standards and are other organizations that are recognized. Do you want to take a cut at that, at some others off the top?
Sure. The first thing I want to observe is that there isn't a concept that there is a white list of standards you're allowed to use and not otherwise. Not in the Oregon law. Okay. We asked Peter Threlkel, and by the way, Peter, thank you so much for your help and the help of your office in getting this bill passed. Peter runs the corporation division. So those of you who screw up your articles of incorporation, it's Peter's fault they come back to. Well, it's actually your own fault. It's Peter's staff that sends it back to you. But we asked Peter whether he'd like the job of checking to make sure that the third-party standards were on a certified list, and he shook his head just like that. So the way the drafting leaves it is you have to pick a third-party standard that is where the organization promulgating it is independent, the standard itself is transparent, that people can see what you're judging against, and it's comprehensive, at least against the list of criteria in the fiduciary section of the statute. But you have to pick it. The company has to pick it. By the way, that means the company is free to help develop it. So FSC might wind up with some corporate governance things that mean if you're a forestry group, you might want to adopt that standard as your benefit company standard. Or if you're an organic grower, it might be that. Or if you're a green building developer, it might be USGBC's LEED standards in some way, adopted in some way. There's a variety of different ways this might come together. There are some standards, including GEARS, and there's a few others out there that are designed specifically for this concept of triple bottom line measurement. I view that set of standards as very important preliminary steps along this. I think the standards are going to wind up figuring out how to be simpler and more direct, and I think that companies that you guys all represent and you yourselves will be participants in the refinement and promulgation of these standards.
Okay, one last question. Go ahead.
So, a couple of the concerns that were versed in the hearings and such on this legislation is, one of them was the expense of it, and I understand it's tiresome, untouchable, et cetera, so we were saying zero expense, I believe, or approximately. But the other one was whether being a benefit company could end up being like a criteria for public contracting, and I was wondering if you could speak to that discussion of whether that'd be possible to do, or
Okay.
why or not.
So we'll quickly answer Diane's question. So the question was, are there any, I guess, is there a movement afoot, or is there a likelihood that being a benefit company might become a criterion for public contracting or other, I guess I call them collateral benefits to the company? I'm not aware of any, Bill. I don't know if you have. I suppose it could happen in the future. I think in Pennsylvania, and perhaps the city of, I don't know if it's Philadelphia or Pittsburgh, I think they've provided to their version of these companies certain benefits, and I can't recall if they are tax benefits or other public, benefits to the company, but that's a good question, and I'm not aware of anything afoot here in Oregon at this point.
So let's address that question in two chunks. One is what happened in the legislative process around that question, because it was kind of interesting, and the second is, are there such movements afoot? Okay. In the legislative process, in the House hearings, there was a proposed amendment advanced by some of the more skeptical members of the committee that would actually have been embedded in the law, that fundamentally said benefit companies don't get any special benefits. Okay. And we all objected to that. And it wasn't just because we have a secret agenda that there will be special benefits someday, right? Not just that, right? It was actually that when you put in a provision like that, you inadvertently create a path through which perfectly normal kinds of things that happen can be foreclosed. So benefits that might be available to other companies would be foreclosed to benefit companies, because in the case of benefit companies, they might be viewed as special. The compromise that happened in the legislation is something that you will see if you look at the session laws and you look at the preamble. And essentially the preamble is like a hyperactive legislative history. And what the preamble says is, by the way, we didn't intend to create any special benefits just by passing this law. This law in and of itself doesn't create any special benefits. And that was fine to address the concerns that the House had, and it sailed through the Senate in the same respect. So this law does not create special benefits. It doesn't foreclose the possibility that at some point, if the state or a political subdivision wanted to create benefits, or if your companies wanted to create special benefits, they could. But this law does not create special benefits. Elsewhere in the country, certified B corporations have gone to city councils and others and said, how about you create a special tax exemption for us, or you create a special bidding preference or some of those kinds of things. Because that history was known, it wasn't foolish for the legislature to have that as a concern about what this statute would in itself do. And I have no doubt that in the overall realm of creativity that people will bring to this process, someone in Oregon at some point will think that that's a great idea and will bring it up somewhere. And that because we have so many different jurisdictions, some jurisdiction is going to think that that's also a great idea and do it. But this legislation does not create that.
Okay, well, with that, we've come up against our hard stop, and we thank you all for coming, and we'll continue the discussion. Thanks.